keep courts open to the media. Be editorial 25 July 2018 to 12:05 am. The NSW Criminal Court of Appeal has just given Chinese billionaire Richard Liu a lesson in the principle that justice must be transparent and equal for all. The online shopping mogul, known in China as Liu Qiangdong, convinced a judge to suppress temporarily his identity in the trial of Longwei Xu, who raped a woman shortly after meeting her at a party at Mr. Liu's luxury apartment in the Rocks. Mr. Liu even persuaded a judge to suppress the use of the words "billionaire" and "penthouse." Richard Liu. Photo, Darien Trainer. In this case the system eventually worked. The order suppressing Mr. Liu's identity was overturned this week after the Herald challenged his application and blocked an appeal. That battle is won, but the war is far from over. Judges are still too free in granting suppression orders, preventing media organizations giving an accurate account of proceedings in open court. It's not a simple subject. There are times when secrecy is warranted to protect rollover witnesses in gang crime cases, or cases of national security, or where it is necessary for reasons of safety. But the grounds for suppressing information are too broad and judges are inconsistent in applying them. A court recently granted a suppression order preventing the naming of a NSW private school even though one of its female teachers pleaded guilty to sex with boys as young as 15. In a case last year, a Debo man was convicted of sexual assault, but the trial judge suppressed his identity. The issue has also arisen in cases of Catholic clergy on trial for sexual offenses. It is perhaps understandable that judges want to get on with trying alleged criminals rather than arguing with highly paid barristers over which details of a case should be made public. But the sunlight of public scrutiny is a crucial safeguard for the integrity of the court system, and it improves the administration of justice. Suppressing a criminal's identity in relation to sexual crimes means the criminal's other victims are left in the dark. The Victoria is proposing to make judges give reasons for suppression orders. Until last month, NSW law allowed judges to suppress information in cases of a sexual nature where it was necessary to prevent undue embarrassment or distress, in response to the scandal over the Debo case. NSW has just passed a law which specifies that the identity of defendants in sexual cases can only be suppressed in exceptional circumstances. There is a concern about the drafting of the law. Judges might read this exception as a license to set a lower hurdle for suppression orders in cases involving national security or safety, or in cases such as Mr. Liu's where the party seeking anonymity is not the defendant. A key test looms in the case of witness K and his lawyer Bernard Collery, who face criminal charges for exposing the unethical bugging by Australian intelligence services of the East Timor government to help Australia cut a better deal in a treaty on oil and gas. The federal prosecutor may be tempted to seek a suppression order or even keep the whole courtroom closed on grounds of national security. Yet there is a balancing public interest in knowing why Australia is prosecuting these whistleblowers. Australia must show the world that we truly value the principle of open justice in this case too.